It's a controversial triple murder case, the trial of Tony Carruthers and James Montgomery, and it may get even more controversial in the next week or so. Aside from Carruthers representing himself in this trial, now, one of the state's former key witnesses is about to change his story.
Welcome back to Inmate Tea with AMP, where we spill the truth for justice and give voice to the voiceless. Today's guest, Tony Carruthers, a man who has spent over 3 decades on Tennessee's death row for a crime he says he did not commit. Tony's case is one of the most controversial in the state's history, filled with missing evidence, unreliable witnesses, prosecutorial misconduct, and unanswered questions that have followed him since his 1994 conviction. For years, advocates and legal experts have called for a closer look, arguing that Tony's death sentence was built not on proof, but on pressure, prejudice, and politics. And now, after decades of isolation, Tony is using his voice to set the record straight, to talk about the holes in his case, the human cost of wrongful conviction, and what it means to live every day under the threat of execution for something you didn't do. So grab your cup, because today we're pouring out the truth about Tennessee's death row, the fight for freedom, and the man still standing in faith through it all, Tony Carruthers. Welcome, Tony. We're glad to have you on the podcast.
Thank you for having me, April and Pete. I really need my voice to be heard tonight. I need the whole world to know the intrinsic fraud I experienced.
Yeah.
And the fraud upon the court.
Yes.
I really need them to... Yeah. Go ahead, April.
So, Tony, thank you so much for joining us. Let's start from the beginning. Tell us about your arrest and how this case against you first gets started.
I was arrested on February the 28th of 1994, and I was taken to the Shelby County Jail. First, I was taken to homicide. I was asked questions. I said, I don't know what you're talking about. I pled the fifth, Miranda versus Arizona. They said, okay, well, we'll take you on down there and lock you up. So they took me to jail and just held me for 3 days. And then 3 days later, an attorney came to visit me and said that my mama had contacted him and that they had found 3 people buried in a cemetery, and that he instructed me, Tony, don't talk to anybody. And I said, I ain't talking to nobody since I've been here. Attorney's name was Ward. And the next day, the homicide officer, Rolderson, came to the jail and charged me with 3 counts of first-degree murder.
Mm-hmm.
And then I went back to my cell, and then 30 minutes later, the parole board served me with a parole hold, because I had been recently released from prison like 4 months earlier. So that's how the nightmare started. So I go the next day for arraignment and general session, and then I set out for a week to get an attorney appointed. Well, not appointed, but hired or whatever. So we ended up hiring the same attorney that came to the jail to speak to me. And I knew this attorney from previous years from a juvenile, so I knew who he was when he came to see me. So we went to general session. It's what they call pretrial. And for about 3 weeks, they just set it off, and then they set it for a preliminary hearing. On preliminary hearing, which was on March 20, 1994, the prosecutor came in and told the judge, Your Honor, we want to drop these cases. We cannot go forward for lack of probable cause. And they dismissed the case in general session. So now I can leave, but I got a parole hold. But the parole verification hearing is for Wednesday, March the 30th, 1994. So I got to wait till Wednesday. So Saturday go by, Sunday go by, Monday go by. Tuesday night, I'm in the jail, and the guys came and said, hey, man, you know y'all on TV? I said, what? So we go in the back. And it was like breaking news. Shelby County District Attorney General and whoever the other people is has came back with an indictment against Tony Carruthers, James Montgomery, and Jonathan Montgomery. What? Yeah. So we go downstairs and get charged. So I come back up. So the next day I got to go to parole board now. So they're like, what do you want to do? We need to put this off so I can go to court and find out what's going on.
Yeah.
So they said the parole ratification hearing off because I can't get released. They did this. So once we get to court, we still don't know what this grand jury indictment is about. And what they in fact did was the grand jury meets the first Tuesday of every month. This was the end of the month. They convened a special grand jury and they went and took a guy whose last name is Shaw. And over that weekend, March 26th and 27th, they manufactured lies with him. A probable cause, a motive, a theory, all made up. And then on a Monday, they had him with the 28th. So we get a special grand jury. And what they did was they convened a special grand jury at the end of the month. So they went and found some people, citizens of Memphis, and took them before and set up a special grand jury and took this guy whose last name is Shaw, which you can see his videos years later on YouTube. They manufactured lies and gave them to him. He said, and then we found out 8 years later that he's actually undercover informant. And how we find that out is he framed a deputy jailer, and the case is on the logbook. And if you read in the logbook, State versus Story, you would see this guy whose last name is Shaw saying we went and picked him up. Well, I'm on post-conviction at this. I've been convicted. So my attorneys filed a motion asking that the state turn over all his files as an informant because it's impeachment evidence, it's exculpatory, and it's material. It would have changed the outcome of the case. So the prosecutor who's actually handled the post-conviction, last name is Campbell, who is now on the Tennessee Court of Criminal Appeals, is the one that took Mr. Shaw to the grand jury to present the lie. So he said, we don't know of any time that Mr. Shaw has ever been an informant for anybody. But he's in the logbook as being an informant. So for 20 years, they just going on and on talking about he's an informant because it's impeachment evidence, and they won't turn over his file. So I got a court order, and the judge ordered him to turn over his Memphis Police Department file, his Sheriff Department file, and his FBI file. We still don't got the Sheriff Department file today, 32 years later. We still don't have the FBI file. But we got the organized crime file. And in the organized crime file, in 1991, he had stole $750 from them. And they alleged like they was going to charge him with a crime and never did. So they knew he wasn't reliable and they knew he was a thief, but they continued to use him. So this guy, this evidence that I would have been able to use pre-trial has been concealed from me for 32 years. So back to the trial.
Mm-hmm.
So what happened is he got cancer and they thought he might die. So they asked for a deposition so they could preserve his testimony in case he died. So we had a deposition in February the 16th, 1995, and that's how we find out what lie they took to the grand jury. First time I've seen him since 5 years earlier, as me and him got into an altercation about the telephone, 1990, September 1990. I hadn't seen this guy since then. So at the deposition, they bring him into the courtroom, and my attorneys get to cross-examine him because they preserving it for the record. So once we hear the lie, I get my attorney, would you please go get the jail records to prove this man ain't been nowhere around me? Go get the incident reports from 1990. But when we get the records, we go back and file a motion, ask the judge, can we get another deposition of Mr. Shaw?
So this man in question was a jailhouse informant in your case?
Jailhouse informant, FBI informant, Sheriff Department informant, and a Memphis Police Department informant. His Memphis Police Department informant number, if you don't want me to say it, I would not say it. His Sheriff Department informant number, I know it, which I won't say it if you don't want me to, but we don't have his FBI file number. He's not just a jailhouse informant. He's a paid informant on the streets who shouldn't have to be paid through Crime Stoppers when he's already on 3 different law enforcement payrolls.
Wow.
He's basically moonlighting through Crime Stoppers. He's tripling his pay.
He's pretty much a criminal that's acting as the police out in
as
the
law
streets,
enforcement.
gathering information. He's out in the streets gathering information for the police and getting paid by the police, whether it's FBI, CIA, SBI, or the Memphis Police Department. He's getting paid by them. And so now for everybody that may not understand what Tony's speaking of as far as a deposition, they took Tony saying they come in and had this man to testify as if he was on his deathbed. And this testimony that this man was going to give in open court and whatever he writes in a affidavit would stand up in trial. And it would be as his actual words. The DA or a designated officer would be able to read it to the courts, and it would stand up in the courts as his living testimony.
Okay.
Well, he's not dead even today. So what happened, we got to see the lie that they took to the grand jury. So now we want to ask for another deposition, and then we're going to ask for it to be dismissed because it's pretty. So we come back to court, and the prosecutor, I'll say his last name, Harris, and Carter.
Okay.
They said, Your Honor, we're not going to call Mr. Shaw. Yeah, what do you mean you're going to call Mr. Shaw? You just put this man on. I mean, he was dying and you need to save this. What do you mean? So the judge said, you're not going to call him. You mean under New York versus Harris? Under no, sir? Not even in rebuttal, no. But if you know I'm on trial, I should be able to take a deposition in case he dies, in case I need to call him. So the judge don't give us a deposition, and he is stricken from the state witness list. Saying, and they said, that's what the reason. And the prosecutor lied and said, this man got caught in a stolen car. Mind you, he was in jail when he made these lies. He had been working for law enforcement since 1986. He had a record 3 blocks long before you took him to the grand jury. And that's not the reason why they did it. That's the lie they told, saying he got caught in a stolen car is the reason why they're going to use him. But what he actually did was, it was another guy who has passed away now. I get this 25 years later. He was trying to frame another guy whose last name is Davis for a murder charge, and he got caught in the homicide office lying. And when he got caught lying, it was videotaped. He was trying to cut his wrist with a coffee cup. And when he ran from the police, when they caught him, he was caught in a stolen car. So they omitted the part that he was trying to frame somebody else for murder and got caught lying. And when he ran from them, they caught him in a stolen car. So now we still got to, we filed several other motions to try to get the case dismissed, try to go back and have a preliminary hearing because they dropped the case in general session saying they have no evidence, circumvented when it convened a special grand jury, denied me all my due process right, all my petitions. So we trying to go back and get these so we can make a record to show that they didn't have proper cause to arrest me in the first place. All that's denied. 6 months after they denied the deposition, they went back to another grand jury and tacked on 4 more charges, trying to change the motive in the theory, because now they don't have a motive in theory. The motive in theory is what's wrote on that Crime Stopper form. It has been proven to be a lie. They have stricken him from the witness list, so now they got to come up with a new motive in theory. But the illegality is indictment can be only amended by the original grand jury. You can't go to another grand jury unless you drop the first indictment. So once they went and amended indictments, they offered me 25 years. I told them, I'm not taking 25 seconds. I'm not involved because the indictments are illegal on the face of the record. You can't amend indictment at a different grand jury unless you drop the first one. So they still proceed. And so when I wouldn't go for the 25 years, that's when the last attorney, whose last name is Massey, started acting real crazy, started accusing me of threatening him, threatening his family. Threatening you for what? So the judge wouldn't let him off the case, so he hired an attorney, and they went to the Court of Criminal Appeals, and they got a court order and forced him off. But while his attorney was going up there to try to get this court order, I got to talk to him in the back. This same attorney name was Massey, represented me when I was 18 years old and got me probation. And I took him back to when I was 18 and how he defended me, and now I'm charged with capital murder, and you doing this? So he said, hold on, Tony. Just give me a second. Let me go ahead and talk to the judge. So he said, Your Honor, he has to be able to bring the judge back in. He came and said, Your Honor, it's on the record. Me and Mr. Carruthers has made up. I'd like to come back on this case. I said, what? You just told me. So I'm making this statement. I never requested to represent myself. It was a ploy because I wouldn't take the 25 years. Ploy by pretending like I'm threatening his family. All that's made up. But we patched that up, and he tried to get back on, and the judge wouldn't let him back on. So they forced me to trial by myself because the indictments are no good. The motive and theories are 2 different theories to 2 different grand juries. So they forced me to trial to represent myself on a manufactured case that they done paid an informant to make up. And here go where Mr. Shaw comes back in.
Now, you're telling us that they forced you to go to trial on a capital murder charge, where in most capital murder charges, a defendant is represented by not 1 but 2 attorneys because you're facing the death penalty. You were forced to trial without an attorney. And in any capital case, you have 2 attorneys. You have a lead attorney and assistant attorney. And then you have a mitigating specialist. And then you got a paralegal. You got a whole big team of people because you're up for the death penalty. And so these people denied you your Sixth Amendment right to adequate counsel to properly represent you on a death penalty case. For one, they didn't allow you due process, and they subjected you to cruel and unusual treatment and unfair tribunal. So then that they did this, you just by you having to represent yourself on a death penalty case is enough to overturn your case and take you back before a trial court to have your trial properly heard.
And the reason why that hadn't happened is because all the attorneys I've had on appeal for 30 years that hadn't got me back on a manifest injustice to get a real trial, they've all concealed the Crime Stopper report, the video that's on YouTube. None of that is in the record. And the Sixth Circuit said there's nothing in the record to show that the state knew Alfredo Shaw was lying when he was testifying. And they actually have the Crime Stopper report, and they have his police statement to show that they manufactured the lie on the weekend. And then they presented the lie to the grand jury. They have clear and convincing evidence that he lied. And they lied and said he wasn't informant, and now they got the file. It's not in the record as of today. The organized crime file that the Justice Review Unit got for me in August of 2024, it's not in the record. Around the country, most guys call it ineffective counsel or legal malpractice. The real term is intrinsic fraud. They pretend to represent you, but they really connive at your defeat. That's why I hadn't got a new trial.
And Tony, for you know, in your case, what you're talking about, this man that actually says, "Oh, Tony told me that he was going to do this," he supposedly, he tells this 2 days before it, you know, on the 28th. You said this man, you know, on the 25th and 26th, he was somewhere else. He was doing something else, but on the 28th, this is when they come at you and lock you up. Now, can you explain for us exactly what happened in that situation?
He was in jail from September of 1993, and apparently he couldn't get out of jail. So from September, October, November, December, he was in the county jail in Memphis and couldn't get out. So when this case came up, they contacted him. But at the deposition of when he had cancer, he pretended like he called Crime Stoppers, and they came over to the jail to see him. But if you read the Crime Stop report, he don't call Crime Stoppers till the Monday. So the statements that he was making pre-trial and in the record were manufactured lies by them. They went to visit him, called him to the homicide office to make up these stories. He was stuck in jail and couldn't get out. As an informant, he had no information that he could get himself out with. So they went and got him and manufactured lies on the 26th and 27th. And then on the Monday, have him to call Crime Stoppers, pretend like you know Tony, pretend like you was in the law library with him, pretend like he confessed to you, pretend like you involved. Because you can't get no hearsay in, so he got to tell a lie. He's supposed to have been involved. He's in jail. It's made up. It's all a lie manufactured by them. It's fraud upon the court. It's aggravated. It's federal crimes against the United States citizens, what they did.
Aside from Carruthers representing himself in this trial, now, one of the state's former key witnesses is about to change his story.
The deposition that was given, Audrey, the statements that were made were coerced. Then I would say coerced, I would say that they were, I was given a police report to familiarize some of the things that was in surrounding the case. Some of the things in here is bits and pieces that were put together for the grand jury by the prosecution.
Back in March of 1994, this man, who's asked us not to reveal his name and to photograph him in silhouette, was brought before the grand jury to testify for prosecutors in the case against Carruthers and Montgomery. According to portions of his taped deposition, he told grand jurors about a conversation he had with Carruthers in the Shelby County jail legal room case, but then said a prosecutor contacted him.
I was contacted by our prosecutor, Jerry Harris, and he asked me about the case and asked me would I be a witness for the state. And I told him, yes, I would. You know what I mean? And then we went on to discuss. You know what I mean? Like, you know, I told him, I asked him, you know what I mean, well, what's in this for me? You know what I mean? He told me that, you know what I mean, when you know you get $2,000, you know what I mean, once you testify.
The prosecution did bring this man before the grand jury, but now claims he's not a credible witness. When we asked this former witness why he's coming forward to recant his testimony after 2 years of silence, this was the response we got.
I was made promises. And my case is dismissed to be a witness in this case.
So in other words, if you fingered Carruthers and the Montgomerys, your cases were going to be dismissed. Is that what was on the table?
Right. The only thing I had to do was go before the courts and testify.
Tony, it's a known fact that this man has even went so far as to fabricate statements against the sheriff. And that case is public record, am I right?
Yes, State versus Story. It's a Westlaw case. It's a 2002 Westlaw 3125783. September 2002. You can pull it up and see the case. And he's framing a deputy jailer 6 months after I get to death row. But if you listen to the video on YouTube, the prosecutor said, this man is a liar. He lied about stuff he don't even know nothing about. That's what he just told the media you paid him to do. So how did you take 6 months later and frame the deputy jailer with him when y'all office in fact said he's a liar? They know he's a liar. They pay him to lie. He's lying for them. And those are federal crimes.
Yeah.
Yes, it's
Tony, for the men, the Montgomery men that was part of this crime, one of them committed suicide and the other one ultimately got convicted, and he got a new trial because they say you and his trial supposed to have been severed.
Yeah.
And they refused you. They have refused you for years the opportunity to get a new trial, and your co-defendant got a new trial, even though you went to trial without an attorney and your co-defendant had an attorney. Can you explain that for us?
I can explain that. We were supposed to have been separated because the informant is framing me and not him. So the Court of Criminal Appeals saying this smells calculated. They say, yeah, Your Honor, it does smell calculated. Because it is. I'm knowing what I'm doing when I put them in the record so I can show the appeal court that y'all are framing me. So the Tennessee Supreme Court denied the first review, but 90 days later when he got to the Tennessee Supreme Court, they say, yeah, it smells calculated, but you can't hold that against Mr. Montgomery. So the Tennessee Supreme Court granted him a new trial saying he was supposed to be severed from me. But in fact, I was supposed to be severed from him. But they saying I intentionally sabotaged the trial. You forced me, an unqualified, death penalty qualified, no co-counsel to represent myself. Of course it's going to be sabotage. It was sabotage when you swore the jury in and made me represent myself. It was sabotage before the trial even got started.
Yeah, exactly.
Yeah.
They saying I sabotaged it. They saying I sabotaged the trial. And if you read the record saying they forced me to represent myself, saying I'm trying to manipulate the system, like I don't want to go to trial. Guys stay in the county jail 5 and 6 years before they go to trial. This trial was had in 26 months. How am I manipulating like I don't want to go to trial? I need an attorney that's going to represent me.
Yeah.
People stay pre-trial 5, 6, 7 years, but you pretend like I'm trying to delay the trial.
Yeah. And
So,
Tony, you know,
he got a new trial.
They overturned your co-defendant's case. He received a new trial. You haven't received a new trial. Okay. What the dilemma is here for me is if your co-defendant was found guilty for the murder of this man and woman, this lady and her son, and the robbery, and they didn't use the informant that supposedly knew all this stuff directly from you, and they didn't use his testimony to convict your co-defendant. I want to know, see, my thing is, how did they get 2 convictions for one crime that they're saying they're not linked together because of this one jailhouse informant that concocted a story and just come forth with it, and he just trumped up something and fed it to the courts, and the courts accepted it when they knew he had told lies and he had been unreliable in the past.
Yes, and I want to explain to you. The prosecutors, the judges, the law enforcement, they are educated in criminal justice system. They are educated in the law. They are educated criminals is how they got 2 convictions. And he was not convicted. He has an Alpha versus North Carolina plea. I have the transcript. He did not plead guilty. He let the state they facts what they would have presented had they gone to trial and let him maintain his innocence and took a 27-year plea. He's been out of prison 10 years. He did not plead guilty. He took Alpha versus North Carolina and maintained his innocence. That's how they got to convict. And that's why they didn't have to use the informant, because he took an Alpha plea. And it's on the street since December the 22nd of 2015.
I understand that an alpha plea says I'm accepting this plea because it's in the best of my interest to accept this plea.
Yes.
But he was still convicted for a crime. He was still convicted of double homicide for kidnapping and burying the body. So at this juncture, they're still severing the two and saying that this one informant that you can prove that none of this never happened, because from my study of your case, it states in your case that the man was never in the law library with you. It states that y'all were never in a cell together at the time that he's saying that y'all were. It states that y'all never had the contact. It's almost impossible for you to give him this story.
Exactly. I want to explain to you what you're asking this way. It's fraud upon the court. All the judicial system know it. To make a man represent himself, to use testimony that you know is perjury testimony, and to sustain a conviction for 32 years, it's fraud upon the court. And here is the fraud upon the court, the way I need to explain it. The testimony by Mr. Shaw never happened. It's made up. It's fraud. They did the same thing 6 months later, Mr. Story. Got a transcript of Mr. Shaw's sentencing hearing in Judge Joe Brown courtroom, where Judge Joe Brown ordered him to be locked up from July the 3rd, 1996 to April the 3rd, 1996 under strict environment. He said, I don't care what big case coming up, you ain't leaving here. You've been lying. They got me to get you out in the Carruthers case. You're lying and saying, they saying you had cancer, you ain't got no cancer treatment, you ain't got no job. You're going to be in strict confinement. You are not to leave. So in January 97, they pretend like the deputy jailer sold him a pound of cannabis. It never happened. They just make the stories up and have him to go in courtrooms and commit fraud upon the court. It's in the law book, State versus Story. That's fraud upon the court. That transaction never happened. And I just sent that transcript to the Innocent Project and the Board of Responsibility. That's why I'm here. It never happened.
So, Tony, from my studies of your case, I see that Mr. Montgomery's brother, the one that, come to his demise while in the county jail, he was one of the ones that pointed the detectives to the graveyard where these bodies were found. Now, in his statements and what he gave to the police, his affidavit he gave to the police, he never, ever said that you were part of this crime. He never implicated you as a person of interest. He implicated his brother, but he never implicated you. And also, you have a clear-cut alibi given a timetable of where you were at, what you were doing throughout this whole ordeal when these people went missing, when these people were robbed, when these people were supposedly killed and buried in this grave. And yet and still, you have an alibi. You had somebody that originally said, oh, yeah, Tony Carruthers done this. Then it turns out that this person that trumped up this story against you come back and recanted his testimony. And these are evidence that would come out in the trial and come out in your appeal. But yet you have sat on death row for 32 years. And there's blatant evidence, there's clear-cut evidence that shows that there is no physical way that you could have been the culprit of this crime or a co-conspirator of this crime.
So put me in the case. They didn't put me in the case. The co-defendant that committed suicide in the jail didn't put me in the case. And you can't cross-examine a witness that passed away. So you can't even ask him which part of his statement that he made is a lie. And all the witnesses in the case have recanted. Even the guy who told the story that Mr. Montgomery and his brother were picked up at 3 o'clock in the evening and taken to a cleaner's, he's recanted. He's a convicted felon. He has recanted. The medical examiner who did the autopsy, he's passed away, but he wrote an affidavit recanting. The Jimmy Mays guy who pretended like I wrote him for prison, he has recanted and made a statement saying he asked them, he want to get paid like Alfredo Shaw been paid. Everybody has recanted they lies, but it's not all in the record. So you read the case from the Court of Appeal, the Tennessee Supreme Court, you read excerpts of post-conviction. You're not reading that everybody recanted, including the medical examiner. So the part about trying to correct the statement about the Mr. Smith guy who's saying that Jonathan and the two Montgomery brothers were riding around. He has recanted. He was a convicted felon who got out on December the 15th and got caught on February 24th with a firearm. So he was supposed to get a federal charge, and to not get a federal charge, he manufactured those lies of who was riding around and who got in the truck. It's all made up, but all recanted.
Wow.
And you're still sitting there. And you're still sitting there on death row for 32 years, facing your ultimate demise of, if you don't get some kind of light shined on your case, if you don't get some kind of help, if somebody don't step up and intervene and realize they got this wrong, you could lose your life. And that is so sad.
On May 21st, 2026, I got an execution date. If they don't make the Board of Professional Responsibility and the Department of Justice in Shelby County investigate all the people that Alfredo Shaw framed for money, it could turn out bad. I'm believing that if enough people get up and scream and ask, did Alfredo Shaw frame a deputy jailer while he was actually in the custody of the Sheriff Department at the Shelby County Penal Farm, and there's no way it never could have happened, then it's almost proof that what he told to the media, that they paid him to make it up. They gave him bits and pieces of story to give to the grand jury, and he asked them how much it ended for him. He said that they said, we'll give you $2,000. But if you look at the Crime Stopper form, they don't put no amount of money on it. It's hidden from us. How much he was actually paid to make up those lies, the federal crime that they committed for paying him to frame over 100 people the same way, if don't nobody investigate, it could turn out bad. But I'm believing in God that the Board of Professional Responsibility, who I sent that transcript to show that he was in custody in January of 1997, and he never could have had any transaction with Mr. Story. And that's proof that he was never in the law library with me, and they paid him to make it up like they did 98 other people. These are federal crimes for federal crime. One last thing I wanted to add to that. People around America in all 50 states that work undercover for law enforcement with badge numbers, aka CI numbers, they have to report their earnings to the United States Treasury, aka the IRS, and its records, and these records can't be destroyed for 100 years. Everybody he ever framed, every dollar he ever paid, has to be investigated and audited to see if he ever reported how much he was actually paid in my case, and did he pay taxes on it. Because none of them have paid taxes on none of the people they framed for 60 years. And that's the proof that they know, and they paying people to commit perjury because they hide from the IRS how much they paying them. They are undercover law enforcement. They criminals, but they law enforcement. They got badge numbers. Police officers got 4-digit numbers, informants got 4-digit numbers. They are officers. They criminals.
To this date, have you received any new legal support, any attention from advocacy organizations, innocent projects, or attorneys that have tried to look into or review your case?
Yes. The Innocent Project in New York tried to get on my case in 2002, and this pro bono firm that I had, the Neal & Hardware firm, kept them off and did the DNA presentation by themselves. They sabotage. They ain't even DNA experts. Then the Innocent Project in Tennessee tried to get on my case in 2022 when Melroy got in office, but my attorneys tried to lump my case in with other guys that's on death row. I'm like, man, what are you thinking? The second thing is, in 2021, I filed a petition for fingerprint analysis and DNA evidence. And the DNA evidence that I have, when my co-defendant got a new trial, they hired a DNA expert, and they came up with 3 suspects. So they didn't use the evidence, but they didn't give it to me. So he took an apple plea in 2006. 2012, I get the DA file from my attorney, which got it in 2008. It had the DNA evidence in there. The court alleged that I sat on this evidence for 6 years, which was a lie. So I was never able to use this evidence. So I put it in the court in 2001. And the Reform Alliance contacted me in January 2025. Tony, you are loved and supported. I need their support now. So I hope that answers your question. I've had a lot of support, but my lawyer and them are sabotaging me. But they can't sabotage the Inmate Tea with AMP from getting out to the public and getting
they cannot.
the country.
They cannot.
What you're doing, man, most people don't understand the resilience, the strength, the dedication, the heart to wake up every morning and say, man, I got to do something to fight for my life. I got to save my life. You fight for your life every day for something you did not do. For you to be able to get up and do that every day, people don't understand what it takes. They don't understand what it takes, man.
The beauty of this situation today, we didn't have social media 30 years ago. Everybody didn't have a phone in hand. You can reach everybody now through social media and through their phone. Mm-hmm. You can get people to hear you.
Yeah.
If you don't get their attention for 1 minute, and if they push tag and share, the story is out. That's the whole strategy. Get the people to push tag and share, and just tag and share. It's going to end up in some lawmaker's phone, some legislators, some lawyers, our social media feed. They going to ask, Mom and Dad, did you see this story? Did you see this man? We didn't have social media and cell phones 30 years ago. That's the beauty of this situation. That's the beauty of this podcast.
Yeah.
So
and
I'm
Tony,
all right.
Tony, what message do you want to leave for those listening, like the advocates, the lawmakers that might hear this, the people out there that are watching this that still believe that the system always gets it right? What message do you want to put out there to them?
That I believe that they don't believe the system get it right, because probably 25 people get exonerated every year for being falsely accused, false confession, and the system knows that they are actually paying witnesses to commit perjury, and that none of the witnesses are reporting how much they earning for the perjury testimony. And that needs to stop, because when you incentivize people to commit perjury, you really put the justice system in a bad light, and it will never be justice in America if you don't stop paying witnesses to commit perjury. And I want the public to ask the system and the lawmakers, why are y'all paying witnesses who have already on law enforcement payroll as undercover law enforcement agents to testify in cases when they're already on the payroll?
Yeah.
It's a prosecution bias, and it's material, and it changes the outcome of every case if you reveal how much you actually paying these witnesses who are already on law enforcement payroll to testify perjurously and wrongfully in courtrooms across America. That's what I want the lawmakers to answer to all their constituents across America, all lawmakers. I'm not the only one. I can text you probably 15 cases right now tonight of people that been did just like me in the last 10 years and had their case overturned. They got a case, Thomas versus Westbrook, a guy on death row. His wife was paid $750 to testify against him. She went to trial. The prosecutor said we ain't gave her one red cent. He went to federal court and the check slipped out. He was on death row in Tennessee. So it's not a one-off. It's not just Tennessee. It's not just Michigan. It's not just North Carolina. It's not just Florida. It's not just California. All these states I'm naming, I can send you cases right now of people that have been falsely in prison and did 20, 30 years on paid perjury testimony. Yeah. And they said, well, that's just how the system is. No, it's not. You know it's illegal. And you know you have to reveal to the jury that your witness is paid. If you read this case, Robinson versus Neal, 592 paid 30, they paid 730. We paid 735. The reason why they don't reveal informants' pay receipt because jurors hate informants and they distrust them. So that's why they conceal how much they being paid. And it's a constitutional violation. It violates the 14th Amendment to a fair trial. The jury is supposed to be able to weigh the credibility of the witness that's testifying before them. And they know if you tell this witness, this juror, that this man is paid and he's been paid since 1980, they're going to automatically discredit him. And that's why they conceal that evidence. But it violates everybody's constitutional right when you conceal that evidence. And that's what they did in the Alfredo Shaw case, and they still doing it. And they got to stop nationwide and make him pay taxes on the money that he's been paid to commit perjury for 40 years.
Ladies and gentlemen, y'all have heard Tony tell his story. This man sits on death row today for a crime he didn't commit. Before I ever met the man, I was convinced he didn't commit the crime. I still believe he didn't commit the crime, and he shouldn't be spending another minute, another second on death row or inside any penitentiary for this crime. I ask y'all as a collective whole to say Tony's name as loud as you can say it, Tony Carruthers. Let the world hear it. Let the world know that he deserves a fair tribunal. Let's get him back in court. Let's come together, join together to save this brother's life.